5 seconds to go. Start. The court must look at the contents of the document and take such document into account as it is. The materials evidence collected by the investigation agency in support of the accusation against the accused in the first information report must prevail until contradicted and overcome or disproved by other evidence. In any case, the question of discarding the document at this stage on the ground of being inadmissible in evidence is not permissible. There is one more decision of this court in the case of Thwaha Fazal versus Union of India, which again deals with the scope of section 43D5 of UPA. After considering the decision in the case of Jahur Ahmad Shah Watali, in fact, in paragraph 24, the case has been extensively reproduced. Thereafter, in paragraph 26, this court held thus. Therefore, while deciding a bail petition filed by an accused against whom offences under chapters 4 and 6 of the 1967 Act have been alleged, the court has to consider whether there are reasonable grounds for believing that the accusation against the accused is prima facie true. If the court is satisfied after examining the material on record that there are no reasonable grounds for believing that the accusation against the accused is prima facie true, then the accused is entitled to bail. Thus, the scope of inquiry is to decide whether prima facie material is available against the accused of commission of the offences alleged under chapters 4 and 6. The grounds for believing that the accusation against the accused is prima facie true must be reasonable grounds. However, the court, while examining the issue of prima facie case as required by subsection 5 of section 43D, is not expected to hold a mini trial. The court is not supposed to examine the merits and demerits of the evidence. If a charge sheet is already filed, the court has to examine the material forming a part of charge sheet for deciding the issue whether there are reasonable grounds for believing that the accusation against such a person is prima facie true. While doing so, the court has to take the material in the charge sheet as it is. As held in the case of Thwaha Fasal, the court has to examine the material forming part of the charge sheet to decide whether there are reasonable grounds for believing that the accusations against the person applying for bail are prima facie true. While doing so, the court must take the charge sheet as it is. Now we come to the offences alleged against the appellant. Offences punishable under sections 13, 18, 18A and 20 of the UPA have been alleged against the appellant. Section 13 reads thus: advocates, abets, advises or incites the commission of any unlawful activity shall be punishable with imprisonment for a term which may extend to 7 years and shall also be liable to fine. Whoever in any way assists any unlawful activity of any association declared unlawful under section 3 after the notification by which it has been so declared has become effective under subsection 3 of that section shall be punishable with imprisonment for a term which may extend to 5 years or with fine or with both. Nothing in this section shall apply to any treaty, agreement or convention entered into between the Government of India and the government of any other country or to any negotiations therefore carried on by any person authorized in this behalf by the Government of India. Stop.